So welcome everyone to Mediation. I am Gary Dickstein. I am your mediator today. Thank you for all being here and for being here on time. The rules of mediation do require a mediator to give an opening statement. I can tell you it's for the benefit of the folks that don't do this for a living. And it's designed to just kind of give you a little heads up about procedurally how this process is going to work today, and so that you understand the role of the mediator in the mediation process. I believe you should know just a little bit about your mediator. I am a practicing trial lawyer, and I have been now for 38 years. I should tell you all I started on the defense side of things. I had my own law firm representing the biggest insurance companies in the state. I did that side for a number of years. After that, I switched sides and I opened my own plaintiff's practice, and I did that for a number of years. Most importantly, I can tell you all that for the last 12 plus years now, I've been a full-time mediator, and I no longer represent clients on either side of litigation. I believe the most important thing I can tell you about the role of the mediator is that I am not here to decide the outcome of your case. You all have not come here today so that I would render some kind of verdict for you. I will share with you as an aside that there are times people retain me to be an arbitrator, and in those instances I do have the responsibility of deciding. But today I'm your mediator, and the way I see my role is I'm simply hopeful that after I have an opportunity to hear the presentations from the lawyers on both sides regarding the arguments and the evidence they would each intend to share with the jury should the case actually go to trial, I am hopeful that when I have an opportunity to sit down with each side privately, based on my background and experience, that I can help both sides recognize where their strengths as well as where their potential challenges might lie should we choose to take this matter in front of a jury. I don't mind sharing with you all. This is my effort as your mediator to see if I can get both sides to do some compromising today. Reason being, I've concluded after being involved in a little over 4,000 of these now, that that's the only way cases seem to resolve in mediation, when both sides are willing to compromise. So I told people from the very beginning, I think the smartest question that anyone can ask a mediator, regardless of what side they're on, is, why the heck should I compromise? After all, I feel for sure both sides feel strongly about their position in the case, so why should anyone, let alone everyone, choose to compromise today? The most honest answer I can give you to that question, at least at this point in time, is because in the end, there is only one alternative, and that involves leaving the decision-making up to six complete strangers. Us trial lawyers on all sides recognize that when we allow strangers to make decisions such as this for our clients, well, we're allowing an element of risk to creep into the equation. That risk comes from the fact that we don't know these six people, so we don't know what they're going to think is important to the case. We don't know what or who they're going to choose to believe, and ultimately we don't know what they're going to do. This, by the way, is precisely the reason why the greatest trial lawyers in our country lose plenty of jury trials they think they're going to win. That comes with the territory of being a trial lawyer. I know we don't read about it in the papers, but this is a reality that all of us trial lawyers know, that we are going to lose some cases we think we're going to win. Now, hopefully we win a few that we thought we would lose to make up for it. But once again, this is our reality. And this right there is the reason why I, as your mediator, I'm hoping both parties have come to the table today in the spirit of compromise. The good news is if we can reach such a compromise today, I can help these lawyers prepare an agreement. We can email it out to you all. You can e-sign it, and the parties will get to put the litigation behind them in short order, which I hope will bring you all some joy today. So the way this is going to work is as soon as I'm done, I'm going to turn the floor over to the plaintiff's lawyer. They will give their presentation, and then we'll have an opportunity to hear the presentation from the defense side. These lawyers are not giving their statements today in an effort for them to try to convince each other. Even though they're both very convincing people, this process doesn't lend itself well to convincing. In fact, the reason we're giving our statements is because we all realize that we are here today in an effort to make a business decision. Unfortunately, that's all any party ever gets at the end of any mediation. We also recognize typically when we're making important business decisions, such as today, the more information we have, the stronger our decision making, because we have more in which to base that decision on, more in which to evaluate our upsides, our downsides, and our likelihood of success. So each party is really here in an effort to understand what the other side plans on sharing with the jury, so that both parties have a complete picture of everything that jury is going to hear, not just what their side's going to tell them before they need to entertain that business decision. The analogy I often give is if we were going to buy a house and we went up to a realtor and asked them information about that house, I am pretty sure none of us would go to that realtor and say, listen, I'm interested in this house. Please only tell me the good things about the house. I don't want to know if there's a leaky roof. I don't want to know if there's a faulty foundation. Only tell me the good things before I decide to buy this house. I'm pretty sure none of us would do that because that would be a crazy way to go about buying a house. And that's not the best way to make a business decision in mediation either. We need to understand everything that jury's going to hear. Our rules today are very simple. First, everything said and done in mediation is confidential. This simply means we cannot discuss it once we're out of mediation. This goes for anybody who might be listening in on any of the backgrounds on Zoom. Second, I'll kindly ask that we do not interrupt each other during the presentations. And lastly, if for any reason you cannot hear, please somehow let us know. It is very important you have a chance to hear each other's positions today. If there are no questions, Mr. Plaintiff Attorney, the floor belongs to you.